we had, with the settlement that we had in Missouri, there's often questions now because we use a buyer representation broker compensation agreement. One, two, they think that because the information is available on the internet, why do they need you? So those are the things I'm going to cover in the next 3 hours. I get what? Oh no, next hour. That's right. That's right. Next hour. I don't want anybody to be too excited here. But I want you to take some things with you that you can explain to your buyers and sellers why you get paid. So let me tell you a little bit about who I am. This is my contact information. Feel free to call me, text me, email me. I will respond to you. I am a baby boomer. So that means if you call me, I'll probably get back to you in about 2 weeks. If you email me, it's a little sooner. And if you text me, probably a little sooner than that. But be persistent. I want to answer your questions. I want to make sure that you have this information. I own my own brokerage, MJC Realty. I have 4 offices, one in Newport Beach, one in Huntington Beach, one in Seal Beach, and one in Palos Verdes. I love the ocean. So that's why we have our offices there. I am also a GRI instructor and have my GRI. The GRI designation is a national designation. It says you took 14 days of your life to gain more knowledge and become a better professional. I am also an instructor with the California Association of Realtors for nigh on a whole lifetime. I teach all of the different designation classes. My favorite is the SRES class, the Senior Real Estate Specialist. I figured, oh, I can get that designation. I can teach, I can sell real estate to old people. And then I figured out I am one. Anyway, it was about communication is what I learned, because Gen X communicates a little bit differently than Gen Y, a little bit differently than baby boomers. So as a designated instructor from the National Association, I teach the ethics class. You say, oh, geez, not that one, Joel. Yeah, every 3 years, you have to have 2.5 hours of ethics. The National Association of Realtors says you have to have ethics every 3 years. Now, in between that time, you don't have to have any ethics, but every 3 years, you have to have ethics. So I've been teaching that class since when I purchased the professional standards course from the CAR back in the 1990s when they decided they weren't going to do the training anymore. If you're on the grievance committee, pro standards committee, or arbitration committee, I bought that particular class and I've been doing that class. It's an all-day class if you're on one of the 3 committees to make sure that you're qualified and knowledgeable to do those kinds of things. And as a certified real estate consultant, I just wanted more alphabet soup after my name. So I got another designation. That's all that's about. Actually, the reason I got that particular designation is when I'm working with buyers. Wait a minute, let me ask you a question. How many of you have ever shown a piece of property to a buyer? You showed them everything, the multiple listing, and they bought through somebody else. Y'all been in the business more than 15 minutes? Well, after that happened to me a number of times, I said, you know what? I'm going to charge them just like any other professional would. You see, I call you professionals because you are defined as such under our state constitution. Yeah, believe it or not, we have a constitution here in California. It was codified in 1879. It says if you have a state issued license, that's the Department of Real Estate, and a requirement of continuing education, that's 45 hours every 4 years, you are considered a professional. As professionals, are we held to a higher standard? Then I want to be compensated at that higher standard. So in 1996, I had a guy come into my office and say, hi, I need you to show me real estate, but I'm going to have my brother's sister's cousin-in-law write up the offer. And I said, what? Well, why don't you have your brother's sister's cousin-in-law show you the properties? Because I don't get paid a dime if you don't use my services. He said, you're not on salary? Whose fault? So I let my clients know I work on, we can't say commission anymore. It's a bad word in California. We have to say compensation. So I work by being compensated by my buyers and my sellers. And I'm going to explain to you in the next hour how I have come as a real estate professional to let my buyers and sellers know what the benefits are, why I get paid. All right, so if you do have questions, throw them into the Q&A. I'll be happy to answer those. If you want to get in touch with me, here's my contact information. We're going to go now. Let's see, we're going to go to new sharing. We're going to go to, let's see, new share. We're going to go to the California Association of Realtors website. Okay, so go to the California Association of Realtors website, new site. This is where it all begins. Now, we got to do some work here to set the stage for this stuff, because you can't just come out and say, hi, you owe me money. Your clients are going to go, oh, why? So I want to set the stage to make sure. There is a lot of information here that I'm going to be using. Let's see, is this showing up? Okay, a lot of information here that I'm going to be showing you. I want you to write down some of the stuff I'm going to be showing you, and I'll tell you when to write it down because you'll never find it otherwise. This website is a huge maze, but it is a grandiose resource for me. I'm constantly on this website because of the information that is contained here. So, first of all, what we have to do is we're going to talk about how we convince buyers that they are going to pay us, and how we convince sellers what we do for a living. So that's what I'm going to do here in this particular seminar. We've got to do some history, though, because this is all coming about because of a court case that happened in Missouri. And it was between the National Association of Realtors and some complainants. The settlement was for $2 billion. Now, I don't know about you, but that's a little bit of money as far as I'm concerned. So I wanted to get more information on how this all came about. 1, 2, how it works. 3, how I can explain it to my clients. So we're going to jump on the Wayback Machine. Now, if you were a kid in the 1960s, there was a cartoon show, and it was about a professor, called him Professor Peabody. He was a dog, and he had a time machine. They called it the Wayback Machine. And he would take his students back in time and he would teach them history. So what we're going to do is we're going to do a little history so we understand where we're coming from in the state of California when we ask buyers and sellers to compensate us. All right. So we jump in the Wayback Machine. We go back to 1620. In 1620, the Mayflower landed. The Mayflower brought with it English common law. English common law says you cannot represent both buyer and seller. They use a two-party debt instrument called a mortgage, mortgagee, mortgagor. And their community property laws are different than they are on the West Coast. Okay, so we learned a little bit. Now we jump in the Wayback Machine. We go back to 1848. We get out, we're in the state of California. Right? Wasn't really a state yet, had a couple of years to go. There was the Treaty of Guadalupe Hidalgo in 1848, when the United States of America obtained the Western United States from Mexico. In that treaty, it said the Western United States must use Spanish law. Spanish law says you can represent both buyer and seller. We use a three-party debt instrument called a deed of trust, trustee, trustor, beneficiary. And our community property laws are significantly different than English common law. Come to August 17th of this year, we have to use buyer representation broker compensation agreements. Now, I got tired of people using my services and not buying real estate through me. So in 1996, my office policy at MJC Realty is you sign a buyer representation broker compensation agreement. If you will not do that, don't let the door hit you on the way out. You see, I've gotten old and grumpy, and I don't want to put up with the boneheads anymore. Now, I'm not telling you what to do. Let me give you my 3 caveats. I have to do this in every class and every lecture that I do. I am also a professor at the University of California at Irvine. I teach real estate at UCI. But I have to let you know, Three caveats, three promises to do or not to do something. Here's all I'm going to do in class today. I'm going to talk to you about 1 to 4 residential units and the laws that are ancillary to those. My second caveat is I will tell you what those laws are. In other words, whether they're business and professions code, civil code, or commissioner's regulations. And I'll give you the situs for it so you can look them up yourselves if you're interested. But my last caveat is the most important, and that is it doesn't matter what I say. It matters what your broker says, because your broker is ultimately liable for whatever you do under 101.3.1 of the Business and Professions Code. So as we go through here for the next hour and I talk about different things, I'm not telling you what to do. You need to go back to your broker, your manager, your team leader, and say, I was in class. I learned some things. What's our policy? So you know how to represent that company as a real estate professional. So we've done our Wayback Machine. We understand what the laws are that rule us. Now, in the old days, 1980s, there were 39 states in the United States that could not represent both buyer and seller. At this moment in time, we only have 8 states. 8 states in the United States, you cannot represent both buyer and seller. Okay. So when this decision came down, I said, I'm not sure what happened here. This particular, we in the state of California have been using an agency disclosure form since 1988. Here's the disclosure form. This form has been required by law in the state of California. And it says, if you represent the seller, you have a fiduciary duty to the seller. If you represent the buyer, you have a fiduciary duty to the fiduciary duty is highest binding trust. That's the definition under Black's Law Dictionary. And it says what we're supposed to do. So when this decision came down in Missouri, I was thinking, how do they do business differently than we do? And I found out English common law versus Spanish law. And I started talking to people about what we do to earn our commissions. Can't call them that anymore. Compensation. What we do to earn our compensation. I talked to several people about that. And all of a sudden, there was a clamoring, if you will, of people saying, hi, Joel, I heard what you said. I need more information on that. So I put together a little talk on this, if you will, to make sure that you understand. First of all, we're not under English common law. We're under Spanish law. We can represent both buyer and seller. The first time this came to my brain was when I was at the National Association of Realtors convention back in New York in the 1980s. Somebody came up to me and they said, oh, you have your badge on. They said, oh, you're from California. I'm from New York. I know in California, you can represent both buyer and seller. We can't do that in New York. We can represent the buyer, we can represent the seller. How do you represent both? I said, it's easy. I'm schizophrenic. Okay. Well, that was just one of those things where, it was an eye opener to me. It didn't occur to me that other people didn't do that. In the 1980s, I just got my real estate license and was having fun. So with that in mind, I want you to understand you in California since 1988 have had a disclosure regarding agency relationship, and you can represent both buyer and seller. It says you can represent both buyer and seller. Okay. So now we have this little changey poo that came up in August, and it said you must use buyer representation broker compensation agreements. So we have this buyer representation broker compensation agreement. You got to sit down with your buyer. You got to say, hi, you have to pay me. Now, I've been doing this real estate business over 40 years, and I figured out most buyers, I say, buyer, you want to pay me? They say, no. Let me make sure we're clear on how this works. Hi, seller, you going to pay me? No. Hi, buyer, you going to pay me? No. Then I'm not going to do the deal. I'm not working for free. If you're working for free, let me know. I got plenty of work for you. We're going to be compensated. Why we're going to be compensated is what I'm going to go over in this particular lecture. These are the things we do that earns our compensation. So what the buyer always says to me is, oh, Joel, listen, I had this happen to me earlier this year. A buyer called up, said, hi, I want to buy real estate. I said, terrific. He said, I've looked at everything on the internet. I found 3 properties I want to look at. So when we got together, he said, Joel, I want you to cut your commission. I said, we haven't even looked at the properties yet. Why would you ask me to cut? He said, because I've done all the work. I have found the properties. In today's market, that's the easiest part. Here's what we do to earn our commission. This particular form is a 5-page form. This is 5 pages. We understand this form and we explain it to our buyers. We also explain this form. This is the agency disclosure form. Let me make sure everybody's seeing what I'm seeing here. Good. This is the agency disclosure form. This form has been required by law on 1 to 4 residential units since 1988. We have to explain this to our buyers and sellers. And I told you, fiduciary, but this is not where we're getting in trouble right now. Where we're getting in trouble right now is this one, to both buyer and seller, to both buyer and seller. Diligent exercise of reasonable skill and care in the performance of your duties. Diligent exercise of reasonable skill and care in the performance of your duties. This says you, I'm talking to you, must be knowledgeable in the area in which you're dealing. All right, let's give me an example. You do residential real estate in the South Bay area. You need to be knowledgeable about the rules and regs of the city where you're selling real estate. You must be knowledgeable about the rules and regulations of the county in which you're selling real estate. All right, so you say, well, what are you talking about? I'll give you an example. I was going to sell a piece of property in Compton. I called up the city of Compton. I said, hi, tell me about, is there any, if I buy a piece of property in Compton, are there any rules or regs that I have to follow? If I sell a piece of property in Compton, are there any rules and regs? I'm talking about 1 to 4 residential units. Remember, 3 caveats. I'm talking about 1 to 4. I'm going to tell you what the laws are that govern those. And it doesn't matter what I say, it matters what your broker says. 3 caveats, okay? So I called up Compton. I said, hi, as a seller. They said, yes, as a seller, we have to do an inspection. I said, what if I didn't know that and I sold a piece of property? The person who answered the phone, probably at the front counter, said, all right, then you would, when the buyer went to sell it, they would find out that they hadn't done the inspections and they would fine the buyer. So the buyer says, whoa, 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 wait a minute. I bought this property from Joel. Joel never told me about this. Guess who's going to get a call? Hi, why didn't you tell me about this? Well, I wasn't knowledgeable in the area in which I dealt. That's what this says. You need to be knowledgeable in the area in which you deal. And I applaud you for being here today because you're going to have a whole handful of reasons why you're compensated in this particular market. All right. So first thing is you need to be knowledgeable in the area in which you deal. A buyer comes walking in and says, hi, I found the properties on the internet. Are you familiar with the rules and regs in that particular city? No. Are you familiar with the rules and regs of that particular county? No. What I did is I call, if I sell property that I've never sold in for, I call that city, I call that county. The last time I called, he said, oh, are you on the internet? Yeah. He said, go here, here's what it is, and here's the list of items. Okay. I'm just telling you what the law says. This is the law right here. This is, you want to know where it is? It's on the back of this agency disclosure form. It's in little tiny print nobody ever reads. 2079 Civil Code. I've read it because as a CAR instructor and as a broker of my company, I need to know this stuff so that I can make sure that my agents are knowledgeable in the area in which they deal. So this particular form says you, representing buyer, representing seller, representing both, need to be knowledgeable in the area in which you deal. All right, so buyer comes in and says, hi, I want you to cut your commission. Why? Because I found the property. No, that's the easiest part. The toughest part is being able to explain this form to the buyer. The toughest part is being able to explain this form to the buyer. This is the buyer representation broker compensation agreement. This is required on all 1 to 4 residential units as of the settlement in Missouri, as of August 17th of this year. Are you ready? January 1st of this year, you're going to be required by law in the state of California that you give this to anybody who buys real property in the state of California, commercial, industrial, whatever. Okay, so you need to know this form. This is a 5-page form, and the buyer's advised to read all 5 pages. You're advised to read all 5 pages. And I've been teaching this class since that, since February of this year, when I sat down with Gov Hutchinson. Gov Hutchinson is the head attorney at the California Association of Realtors, and he explained this particular form, what the concept was. Now, I've been using a buyer representation agreement. It wasn't exactly this one since the 1990s. So I have a feel for what goes on here, but how to explain it to my clients when I say to a buyer, you need to pay this. And the buyer says, I don't have any money to pay this. All right. So let's make sure we're clear on this one. Are you ready? Are you sitting down? Where does the seller get the money? In the old days, last year, if I had a buyer, let's do this. Let's get on the Wayback Machine. Let's go on the time machine again. We went to 1620, English common law. We went to 1848, Spanish law. Now we're just going to go back 10 years. 10 years. We're going to get in the Wayback Machine, go back in the time machine 10 years. We're going to get off the time machine. We're going to go into an escrow office. We're going to say to the escrow officer, 10 years ago, 2014. Hi, have you closed the transaction? Yes, I have. I have the buyer's closing statement and seller's closing statement. Now I'm asking you, on which closing statement was the commission paid? Buyer's closing statement or seller's closing statement? It was paid on the seller's closing statement. It's always been paid on the closers. They're the one. Now, here's what nobody knows, or they knew it, but they just didn't realize it, or they realized it, but they just didn't inculcate it into their sales routine. Where did the seller get the money to pay me my compensation? From the buyer. Nothing's changed. They just didn't know it. The buyer gets a loan, the buyer gets the down payment, they give it to the seller, seller pays me. The seller's always paid us, but they got the money from the buyer. So when we look at this buyer representation broker compensation agreement, nothing new. The buyer gave the money to the seller. Now we're just telling the buyer, hi, buyer, you got to pay me. The buyer says, well, I don't have any money. That's this area down here where it talks about, I don't have any money. I'm using a loan product. Well, first of all, they've always had the money. They give a loan, they give a down payment, and the seller pays us. So that's moot. And there are no loan products out there at this moment in time, FHA, VA, Calvet, that will not let you finance the commission. I've cleared that with all 3 of them. I talked to the head honcho, Ernesto in LA, VA. He talked to his boss in Washington, D.C. I talked to the head honcho for FHA in Washington, D.C. at Reimagine. Remember Reimagine? Reimagine was in September. It's our expo for the California Association of Realtors. I talked to Calvet, California Veterans Administration, and they said, yes, you can finance the commission. So this is all moot. This is okay. They do have the money because they give the loan and the down payment to the seller. Here's where things get hinky. So the buyer looks at this and the buyer says, I can't pay you. No worries. What we're going to do is we're going to come down here to the purchase agreement. In the real estate purchase agreement, this is the residential purchase agreement. This purchase agreement, I want you to understand, you are not a party to this agreement. It says right here, on the first page and it says it on the last page. Buyer and seller referred to as parties. Brokers are not parties to this agreement. You are not to be telling your buyer and seller what to do in a residential purchase agreement. You are to give them options and they are to make their decisions. In deference to, if we go to our buyer representation broker compensation agreement, you are a party to this agreement. You come down here, the buyer signs and the broker signs. You're not a party of the purchase agreement. The buyer says, oh yeah, I'll pay you, but I don't have any money. Huh? You're going to give the money to the seller. And you, buyer, because I am not a party to this agreement. Remember, it says it right here on page 1. You say, well, what you said it says it on page 17. This particular form is now 17 pages. Okay, last week it was 15 pages, now it's 17. Hold on, we're not even to the end of the year yet. If you go to the last page in this agreement, this is the broker page. We get our own page, page 17. And it says on page 17, the broker section, it says real estate agents are not parties to this agreement. And yet you sign it. My question is, well, why am I signing the dadgum thing? You're signing it because you're confirming your agency relationship. The first form is your agency disclosure. By law, you must give this to the buyer and seller at a specific time. Now, we never read stuff we sign. I tell you, I hate reading this stuff. I really do. But I know if I don't read it, I always get myself in trouble. And this form says, if I represent the seller, I got a fiduciary duty. If I represent the buyer, I have a fiduciary duty. If I represent both buyer and seller, I still have a fiduciary to both. All right. Got it, Joel. Understand that. But this is a 3-step process. You must give them this form at a specific time. You must then check off boxes on the first page. If you look at the law, it's 2079 Civil Code. It says you got to give it to them at a specific time. I'm going to tell you when that time is. It's on the first page of your agency disclosure. Then you have to check off boxes. And the law does not say you have to check off any specific boxes. It just says you must disclose your agency relationship. Whatever your broker policy is, whether you represent the seller exclusively, buyer exclusively, or both buyer and seller. Does not matter. You just got to check off boxes. The last thing you do is you sign the purchase agreement. By signing the purchase agreement, you're saying you are that person's agent. That's all. You're not a party to the contract. It says specifically right here, you're not a party to the contract. So my question has always been, all right, fine, I'm not a party to the contract. Why am I signing it? I'm signing it because it's a 3-step process. You give them this agency disclosure form at a specific time. It says right here, you hand this to the buyer, you hand this to the seller. They read it. It says the law requires each agent, that's you, with whom you have more than a casual relationship, whatever that is, to present you with this disclosure form. You're to give it to them at a specific time. Here's my office policy at MJC Realty. You start showing the buyer property, you form more than a casual relationship. You give them a copy of this. You go on a listing presentation, you form more than a casual relationship. You give them a copy of this. Now, I don't know what your broker policy is. Remember, third caveat. Doesn't matter what I say, matters what your broker says. So you're going to have homework. You're going to have to go back to your broker and say, hi, I was in class today. I learned some stuff. What's a casual relationship? Under the law, here's the code right here, 2079 Civil Code. And if you do not do this properly, it says right back here on the back page, you are not entitled to compensation. I don't know about you, but that's how I get paid. Last week it was commissions. Today it's compensation. Okay, can't use certain words. Okay, this is just like what was that? 1984. It's closer than you think. All right, so you say, okay, Joel, I got this. I got to give him this form at a specific time. I'm not a party to the contract, but what do I get paid for? We're going over it. You have to explain this to the buyer. You have to explain this to the seller. Then you have to explain this to the buyer and seller. This is 17 pages. Well, let's make sure we're clear on this. Who wrote up this contract? Not who filled it in, we filled it in. Who put this standard form together? Who do you think put it together? Oh, you think attorneys? Wrong answer. It was put together by realtors such as yourself. It is a committee at CAR called Standard Forms. I was on Standard Forms in the 1980s when the purchase agreement went from 2 pages to 4 pages. I said, nobody's going to sign this thing. They said, oh, we need your help. It was like hitting my head against the wall. It felt so good when I quit. Because here's what I figured out. Every time we lose a major lawsuit, it's good for another paragraph in this thing. And I've been proven on that one, 17 pages. And we're going to have changes on stuff. We got 7 new forms coming out January 1st. 30 updated forms. I'm just telling you, you need to be knowledgeable in the area in which you deal. And I applaud you for being here today because you're going to know more about why we earn our compensation. The 90% of the agents out there in your association, they haven't got a clue why they earn it. Right? First of all, they don't understand where it came from, this settlement. Second of all, they don't understand how to explain this. You need to be knowledgeable in the area in which you deal. You need to go through this with your buyers and sellers, and you need to explain these things. What I've done is I've taken my time, effort, and energy. Real estate's been very good to me. I'm taking my time, effort, and energy to make sure that you are knowledgeable in the area in which you deal by giving classes on the RPA, Residential Purchase Agreement, the RLA, Residential Listing Agreement, and the BRBC, as well as the 48 standard disclosures in the sale of a single-family home, owner-occupied in the state of California. 48! I'm going to show you where that is because this is what we get paid for. It terrifies me when somebody calls up and says, hi, I'm a for sale by owner. I say, are you familiar with the purchase agreement? This is the residential purchase agreement. You're going to have to fill this out. You don't have a clue what these different things say. I can just put it on the back of a napkin. Yes, you can do that. And escrow will take care of the rest of it. No, they won't. They're an independent third party. They are to take the information you give them, make sure it complies with everything that's going on, and then get the money in one hand, the deed in the other hand, and switch. They're not to tell you what to do. If they do, they're in violation of real estate law because you have to have a license under 10131 of the Business and Professions Code in order to give this information. You have that license. Okay, so you understand the purchase agreement. You understand the residential, the buyer representation agreement. You're going to have to explain these to the buyers, to the sellers. You have a listing agreement. So let's go down here to the listing agreement. This is the residential listing agreement. You're looking at these forms. I'm a certified forms trainer. I've been for many years now, teaching all the classes in a CAR. The last time we got certified, we were certified in like 50 forms. I said, ooh, 50 forms, that's pretty good. Then I looked at this. These are all of the forms you could possibly have in a real estate transaction in the state of California. Now, I'm a numbers guy. I looked at this, I went, how many are there? I counted them. We have 259 forms that you could use as a real estate professional in the state of California. And they tell you, don't practice law. What? So we come up here, we're talking about the listing agreement. This used to be a 5-page form. It's now a 7-page form. It's now 7 pages that you have to explain to the seller. But that's just the listing. They have what they call the bundle of forms. Those bundle of forms start out with the agency disclosure form. If we go to this is a 7-page. Remember, we're down here. This is the listing agreement. This is a 7-page listing agreement that is 19 pages long. This is what we do to get paid. We tell them what the rules and regs are involving representing a buyer and seller. And then we make sure that we give them a copy of this. The last form, number 19, is the California Consumer Privacy Act. This is the disclosure. If it says disclosure, it's probably required by law. This says they have the right to opt out. Now, if the seller doesn't, they go for sale by owner, or they ask us, what do you do to earn your commission? I make sure that your information is protected by law. Why? What law? California Consumer Privacy Act. You need to read this stuff. You're asking people to sign. The next form is the fair housing. This is an advisory. The advisory is probably not required by law, but it has a lot of great information in it. The information that I always stress is protected classes and examples of conduct that may not be motivated by discriminatory intent, but that could have a discriminatory effect. Now, all of you had to take your ethics class. You say, wait a minute, I had ethics when I renewed my license. Well, if you renewed through REVI, the Real Estate Video Educational Institute, you got not only 3 hours of continuing education to renew your license with the Department of Real Estate, you got 2.5 hours of education for the National Association of Realtors and the 17 articles in the Code of Ethics, as well as the 3 standing committees. If you didn't, you're going to have to take a separate class. It's a 2.5-hour class, and I've been teaching it since the 1990s. It talks about 9 protected classes at the federal level. Those 9 protected classes are race, color, sex, national origin, religion, familial status, that's the makeup of the family, handicap status. In California, we call that disability, sexual orientation, and gender identity. Those are the 9 protected classes at the federal level. You're in the state of California. In the state of California, we have 22 protected classes. These are all the protected classes. You cannot discriminate against them, or you're in violation of fair housing. Sellers don't know this. Buyers don't know this. They haven't got a clue. This is what we get paid for. The next item is examples of conduct that are not motivated by discriminatory intent, but they could have a story. What the heck is that? Those are the buyer love letters. This is a letter. Buyer says, oh, I love this house. I want to write a letter. I want you to give this letter to the seller. The letter says, we love your home. We'll treat your home like you did. We'll raise our children here like you did. Please accept our offer. That could have a discriminatory effect without the intent. On your RLA, residential listing agreement, it says you, I'm talking to you, will not look at those letters. 1, you're the listing agent, you get an offer in, it's got a buyer love letter with it. You're not going to look at it. 2, it says in there, you're not going to show that to the seller. What do we get paid for? We get paid for protecting you because, if you violate, this is a federal law. Okay, these are the federal laws. This is Federal Fair Housing Act, California. If you violate the federal law, do you know who comes knocking on the door? FBI, Agent Scully or Mulder. I don't want to hear the knock. You need to be knowledgeable in the area in which you deal. By having that knowledge, you are earning your compensation. This is the reason you get paid, is because you're explaining this to the buyers and sellers so they do not get the knock. The next form up is the possible representation of more than one buyer and seller. This is the disclosure and consent. When I looked at this, I said, oh, this is nothing more than an update of the first form, the agency disclosure. Because in the agency disclosure, that was written in 1988. This is the only form, no, it's not. This is one of 2 forms that was given to us by the state legislature. This one was given to us in 1988. The TDS, transfer disclosure form, which is required by law in all 1 to 4 residential units. What am I talking about here today? 1 to 4. That was the other form, only 2 forms. Every other form that we have was given to us by standard forms. Realtors such as yourself, they meet on a consistent basis and they put these forms together. They then give it to the legal staff at the California Association of Realtors to make sure it's admissible in a court of law. So when I look at these forms, I go, dadgum attorneys, I'm not, there's no attorney involved in this who made it up. I'm mad at myself because we are the ones who put these forms together. We make sure they're admissible in a court of law by giving them to our legal staff at CAR. So when we're talking about these different items, we go all the way down here. We talked about the California Consumer Privacy Act. We talked about the discrimination, federal as versus state. And now we get to disclosure. This one is an update of the first form, the agency disclosure, because it was written in 1988. They didn't talk about multiple buyers and multiple sellers, and their definition of dual agency was crummy. Here's the one that gets us in trouble all the time. Realtor A has a listing. Realtor B calls up, says, hey, I want to make an offer on your listing. Realtor A says, send it on over. Realtor B sends it over to him. My buyer calls me up, says, hey, I want to make an offer on Realtor A's property. I say, okay. I call up Realtor A. Hey, property still available? Yeah. Got any offers? Yeah. What are they? Can Realtor A tell me what Realtor B's offers are? Offers are not necessarily confidential. Buyers advised that the seller or the listing agent may disclose the existence of the terms or conditions of the buyer's offer. It's right there. It's signed by the seller. It's signed by the buyer. It's signed by the buyer's agent, signed by the seller's agent. There is no excuse for you not to know this exists. Except I've been taught all my career you couldn't do this. This is a newie. That's why you need to take classes more than 45 hours every 4 years, because stuff changes and it affects your ability to do business, number one. Number two, your ability to earn compensation. You got to make the buyers and sellers knowledgeable. They don't know this. As a matter of fact, this is in your code of ethics, Article 16 of your code of ethics. This is the bundle of forms we're talking about in the buyer representation broker compensation agreement. We're talking about a 5-page form that is 19 pages long. Okay, because there's other forms that are put with it to protect you, to protect the buyer and the seller and you. This is what we get paid for. We don't get paid for finding property. I love it when this guy comes up to me and says, hey, I found the property. I'm going to cut your commission. Whoa, whoa, whoa. In the 80s, we had multiple listing books. If you had a license in the 80s, you had a book. The book was like a telephone book. Somebody wanted the information, they had to come to you. That's not the way it is anymore. The information is out there on the internet. We're not paid to find the properties. They can find them on their own. What we're paid to do is make sure we explain all the forms, know all the laws that are ancillary. Do you know how many laws they passed in the year 2023? 2023, last year, how many laws? Over 900 laws were passed just in Sacramento. Just in Sacramento. And they tell you don't practice law. So you got to give this to them and you got to explain to them. That's what we get paid for. They had no idea about this. The next one is the broker compensation agreement. So if we come up here to the broker compensation agreement, it's a 2-page form and it says, hi, in the listing agreement, here's what you're paying. It is optional, okay, if you're unrepresented. And the listing agreement talks about unrepresented. When I do my class, I explain what that means and what the lawsuits are that involve that. You may represent both buyer and seller. California, we can be dual agents since 1848, okay? Then we come on down here, buyer representation. Written agreements, they must be in writing to be admissible in a court of law. And enlisting the real estate broker to represent them, the person responsible for that payment may be negotiated. I'm going to tell you how we're going to get paid here before we end the class. Do you need to have permission from the seller to disclose specific aspects of the offer? Okay, so now we're back here to this form. The possible representation of more than one buyer and seller. It says, buyers advised the seller or the listing agent may disclose. So the question is, well, what if the seller tells you not to? What seller in their right mind would tell you they don't want more money? They always say, hey, bid this puppy up. Tell everybody I want to get the highest price I can. but you bring up a good question. Because in this instance, if we represent the buyer, I've never had a buyer say, oh yeah, tell everybody what my offer is. They say, no, I don't want that. If you're writing this up for the buyer and the buyer says they don't want it, you have to get what's called a confidentiality agreement. And the 259 forms, do you think we have a confidentiality agreement? Go like this. We do. So that's a good question. From the seller's aspect, they love this. From a buyer's aspect, But relate to this in our class when I do the buyer representation broker compensation. If the buyer says, I don't want the seller to tell what other offers are, the seller's going to say, wait a minute, I got 4 other offers here. They're not asking for that. You're asking for that. I'm not even going to look at yours. I'm going to go with the 4 I've got. So there might be a ramification there. All right. So we come back up here. We're talking about, this is what's called the broker compensation advisory. It's not required by law, it just says, hi, if I represent you as the seller's agent, here's how you get paid. If I represent you as the buyer's agent, here's how I get paid. Okay. So it's just a disclosure. Seller pays compensation. It's negotiable. Good. And I love it when they say to me, hey, Joel, on this buyer representation broker compensation agreement, if we look at this here, it says on the residential listing agreement, it says the rate of commission is not fixed by law, it's negotiable. It says this not only on your listing agreement, but on your buyer representation broker compensation agreement. Whenever they say, oh, so it's negotiable, huh? I always say yes, up. Now you have to do it with a straight face. Otherwise, I don't know why they think they can come in and tell me, I want you to cut my commission. Wait a minute. I don't come to you. What do you do for a living? I wouldn't come to you and tell you, cut what you're earning. I would never do that. That's not how it's done. But because there's other agents out there that will take less, that's fine. I know I've been doing this business for over 40 years. In 1982, I formed MJC Realty. I know what it takes to pay the insurance, pay the costs, pay the memberships, pay the rent on the buildings, have all the education, all of the necessary items that go into running a business. And I know what it costs me. And I know why I charge what I charge. Now, I can't talk about a percentage in this class because that's price fixing. But understand that you've got to make a certain amount of money, compensation, in order to pay your bills. And I made a deal with my family many years ago. I would help support them. Okay, so let's see here. Do you need to have permission of the seller to disclose specific facts to the others? No. Now, okay, now we get into another area. All right, so in here, we're governed by a court case, and this court case happened in 1984. It's called Easton versus Strasburger. Easton versus Strasburger says you must disclose anything. You and the seller must disclose anything that would affect whether the buyer would buy or seller would sell, depending on which side you're on. That was a court case. Happened in 1984. They codified that. They put it into our code in 1986. In other words, you as real estate agents must disclose anything. And that's why we have 48 standard disclosures in the sale of a single family home owner occupied in the state of California now. That's the granddaddy, 1984, Easton versus Strasburger, codified under 1102 of your civil code. It's on paragraph 11 of your purchase agreement. And it says you must disclose anything. So now if the seller tells you don't disclose it, you got to make an economic decision. Do you not disclose it, the buyer finds out about it and sues you? Or do you disclose it and the seller finds out and they sue you? Who will sue you for the most? That's an economic decision, okay? So with that in mind, we want to make sure we are disclosing what we can legally disclose, number one, and number two, that anything we do disclose, we get permission from. My office policy is I say, hi, I have to disclose this. Seller says, oh, okay. I say, fine, sign here. Hi, buyer, I have to disclose this to the seller. Seller says, go ahead. sign here, so that it's not me making decisions. I'm not a party to the purchase agreement. It is them saying it's okay for me to make this disclosure. Now, I don't know what your office policy is. You're going to have homework. You're going to have to go back to your broker and say, hi, what's our policy on this? Because you need to be knowledgeable in the area in which you deal. Okay, so we're back here and we're talking just the bundle of forms. This is the listing agreement. So this is a 19-page form. It starts out with the agency disclosure. The last page is the Consumer Privacy Act. Then we get to an advisory on fair housing. Then we get the disclosure regarding possible representation, more than one buyer and seller. Now our broker compensation. This is in both the listing agreement, the RLA, and the RPA. If we come back here to the BRBC, and we come down here to last form is always going to be your California Consumer Privacy Act. It's not required by law, except that they have the right to opt out. That's the kicker here. The next item, possible representation, more than one buyer and seller. Then we have broker compensation. So it's in your BRBC as well as in your RLA, buyer representation, broker compensation agreement, and in your broker listing agreement. Okay, we got all that, Joel. Fine. If we go back here to our residential listing agreement, and this is where you have to understand, you can have all the listing agreements you want with the buyer or with the seller. Unless you get an offer, you don't get paid a dime. You can have all the offers you want. You can have all of the buyer representation, broker compensation agreements that you want. Unless you get a buyer that signs a purchase agreement, you don't make a dime. The one that you make a dime in is your purchase agreement. And then the purchase agreement, you're not a party to it. So you need to make sure you're knowledgeable in the area in which you're dealing. And that's why when I go over these classes, I go through every paragraph, because you need to be knowledgeable and be able to explain it to your buyers and sellers so that when they say, why am I paying you? Here's the reason. Now, what I want to do is I want to make sure that you understand that you are a party to the listing agreement. The broker, it has a place for the broker to sign. You as an agent are a party to the buyer representation broker compensation agreement. There's a place for you to sign. You're not a party to the purchase agreement. The listing agreement and the buyer representation agreement, you are a party to, and you can sign it. It says broker or agent can sign it, and you have an independent contractor agreement with your broker. That independent contractor agreement says you can sign on the behalf of your broker. You all have one of those, right? It's required by law. It's the one that has your commission agreement in there. Oh, yeah. Okay, now you know, you got it. Okay, good. So you can sign on the behalf of your broker. You sign all of these forms on the behalf of your broker. You are a party of the listing agreement. You are a party. You are, because it says right down here, the seller signatures and buyer signatures. You are a party to the buyer representation agreement. You are not a party to the purchase agreement because it says right in the residential purchase agreement, it says you're not a party to it. The only reason you sign it is to confirm your agency relationship. That's the only reason you're signing this thing. Okay? So you can have all the listings you want, you ain't going to get a dime. You can have all the buyer representation agreements, you're not going to make a dime. You need a purchase agreement. You need one of these signed, and you need to be knowledgeable in the area in which you deal. So when I sit down with the buyer, I sit down with the seller, and they say, I want to cut your commission. I say, this is the reason I earn my commission. I'm going to explain. This is a 17-page form that is 27 pages long because it includes the bundle of forms. These are forms that your standard forms, realtors such as yourself volunteer their time, put these forms together, think you should have. One, two, that your attorneys at the California Association of Realtors think would be a good idea to keep you out of jail. I mean, out of court. So when I give this out to them, I'm not a party to this, but I am a party to the listing agreement. I am a party to the buyer's representation agreement. Now, this whole thing is how I'm going to get paid. The buyer says, you are worth the money. The seller says, great, you got all this knowledge. I'm happy to pay you. How do you get paid? Well, there was a magical thing that happened about 2 years ago. It was March of 2022. In March of 2022, the residential purchase agreement changed. On page 2, at the top of page 2, third paragraph down, it came up with a new form. It was called the Buyer Representation Obligation to Pay on a separate agreement called an SPBB. This is Seller Pays Buyer Broker. I'm a certified forms trainer. This came up. I said, I don't have a clue what this is. This was in March of 2022. They don't change the forms. Then they change them December and June. They got to push to July of this year, and they probably be pushed to January of next year. But when that came out in March, I said, what is this form? Well, this form was standard forms crystal ball, because what they said is, wait a minute, buyer, do you want to pay me? No. Then we have to get the seller to pay me, as they always have. And the way we do that is we use a SPBB, Seller Pays Buyer Broker. This is my office policy. You include this on every purchase agreement. I represent the buyer. I'm writing up an offer for the buyer. I say, buyer, you want to pay me? I've never had a buyer say yes. They always say no. Okay, if you don't want to pay me, then we're going to have to ask the seller to pay me, just like they always have. The seller's always paid the commission. They just got the money from you, and you didn't know it. So on this SPBB, it's a one-page form. We look at this particular form. We come up here to search, and we put in SPBB. My office policy is you include this form with every offer, unless the buyer says, no, I'll pay you out of my pocket. I've never had that happen. Okay, 40 years of business, never had that happen. It just basically says seller, and they can pay it through a concession or anything they want, but I'd be careful of that concession. Seller's payment of buyer broker compensation. So you include this form. It's a one-page form. They sign it. They have always paid the commission. Good. We come back here to our purchase agreement. Come back here to our residential purchase agreement. We're not a party to the contract, but we can ask the buyer. I'm not a party to it, so I can't ask, but I can ask the buyer. Buyer, you want to pay the commission? No. Then ask the seller to pay. Buyer says, okay. So they always put this in. Seller says, I'll be happy to pay. I always have. But I got the money from you. You get a loan, you get a down payment, you give it to the seller, seller pays my commission. So when they ask us, what do we do to earn our commission? We go over the purchase agreement, we go over the listing agreement, we go over the BRBC. We explain all the forms that are attached to it. And the last thing we do is we go to the California Association of Realtors website. You might want to write this down, because here's where the 48 standard disclosures in the sale of a single family home are. About 20 years ago, I was just clicking around on stuff. Now, you always know you're at the California Association of Realtors website because there's somebody sitting on a house. I'm not sure what the significance is of that, but I know I'm at CAR. Go to Transaction Center. Click on Transaction Center. Gives you 4 more tabs. Go to Risk Management. Is risk management a big deal? Go like this. You click on Risk Management. You come down here to Disclosure Charts. Now, when I clicked on this, it was Disclosure Charts, singular. We now have 4 disclosure charts. We have REO disclosure chart if you're selling bank-owned property. We now have a lease disclosure chart because we're a tenant state. We have a new home disclosure chart because those of us who build houses are from a different planet. And we have the sales disclosure chart. This is the one I clicked on. 20 some odd years ago. This was put together by Member Legal Services. Area code 213-739-8282. That's the legal hotline. These are real estate attorneys. You can call them up and you can ask them legal questions about real estate, not about divorces, okay? This was updated as of February of this year. It covers 4 different areas. 1 to 4 residential units are the first 3 columns. This is the column I counted for 48. I just counted all the yeses. If you're doing probate, this is the column. If you're doing foreclosures, this is the column of disclosures. If you're doing 5 units or more apartments, this is the disclosures required by law. Here's the law right over here. If you're doing commercial properties, industrial. "53 disclosures, of which 48 are required by law." There are 53 disclosures. Some, I just counted the first paragraph, the first line of information. Some of these are not required by law. It says right here, environmental hazards disclosures are not required on a 1 to 4 residential unit standard sale. You need to be knowledgeable in the area in which you deal. And if you are, you've earned your commission. This is what we get paid for now. We don't get paid to find properties. We get paid to demonstrate the properties, hold the open houses, work with the escrow, work with the inspectors, explain these forms, work with buyers, and put the transaction to sleep so that you earn your commissions. Again, my name is Joel Carlson. I'm a real estate broker. Here's my contact information. Please feel free to contact me, email me, text me. I am happy to talk to you about this. Okay? But remember, if I don't respond back in a couple of days, call, text, email me again. It's not that I learned a new word. It's not that I'm ghosting you. It's that I got plenty of things to do. I'm running 4 offices. I belong to 4 associations. I am a past president of my association. I am also a mucky muck with the Kiwanis and serve on several other where we give our time, effort, and energy at no compensation. In the words of a famous real estate attorney, go out there and sell something. I need the money. See you in the next class.
Thank you, Joel. Thank you, everybody, for showing up today, and have a wonderful day.
I shall do so. Bye-bye now.
Bye.